Constitution, to which extent it was correctly so declared. I would reject this ground of appeal. The fourth issue is on presidential immunity. In his petition, Force 26 of 2020, Isaac Aluochier versus Uhuru Muigai Kenyatta, Mr. Aluochier asked the court to determine whether the president can lawfully initiate a constitutional amendment through a popular initiative process, whether the president can establish a steering committee, and whether the steering committee had locus standi to promote constitutional changes pursuant to Article 257. It also sought from the court to determine whether civil court proceedings can be instituted against the president during the tenure of office in respect of anything done or not done in excess of powers donated by the Constitution. Before us, while highlighting his submissions, Mr. Aluochier complained that the two superior courts below made pronouncements that were wider than his original prayers, where he had only sought a declaration that the president had acted outside the functions of his office by unlawfully establishing the steering committee, for which he ought to have been held liable. The Court of Appeal, having arrived at the conclusion that the president was not heard in his defense on allegations of breaching Chapter 6 of the Constitution, it was moot to consider whether the president was properly sued in his personal capacity, all the orders made against him in that capacity having been set aside. Consider, too, that both courts nullified the popular initiative on the ground that the president was not qualified qua president to initiate it, confirming that his actions, the Gazette notices and so on, were official. Mr. Aluochier's question was effectively answered, that no civil proceedings could be instituted against the president in his personal capacity in respect of his role in the proposed amendment. That would have been sufficient to conclude this ground. I cannot agree more that the route taken by the High Court and the Court of Appeal in responding to Mr. Aluochier's contention was respectfully slightly overboard. Their determination of the matter in the manner they did has, however, presented a chance to this court to express itself directly on the question for the first time. Under Article 131 of the Constitution, the people of Kenya acknowledge the immensity and the enormity of the office, and declared that the president shall not hold any other state or public office except that of the president. Again, because of the exerting nature of those responsibilities, the Constitution grants the president immunity to enable him or her to discharge the functions, ability, and peace of mind as possible. Because the president's actions while in office are actions of the state and not personal, any person who is aggrieved by the exercise of state power by the president has a recourse. First, to challenge the action in court by naming the Attorney General as a respondent in a judicial review application or a constitutional reference. Or secondly, to institute civil action at the end of the president's tenure, because Article 143.3 holds the time from running for the wrongful actions committed while in office until the president leaves office. And of course, there is the option of impeachment motion, which may be moved in Parliament against the president for engaging in gross violation of the Constitution or of the law, or committing a crime under national or international law, or for gross misconduct. The Court of Appeal fell into error in the manner it construed Article 143 of the Constitution. And for these reasons, I would set aside the judgment of the Court of Appeal to the extent explained. The fifth issue was the place of public participation. The twin questions before us are specific. the place of public participation under Article 10 in relation to the role of IEBC under Article 257(4) of the Constitution, and whether there was public participation generally in respect of the draft bill. Public participation today is a constitutional imperative recognized as one of the principles of good governance and accountability. A reading of Article 257(4), the role of IEBC is to verify that the initiative is supported by at least 1 million registered voters upon receipt of the draft bill and the 1 million signatures. I've already, in the previous paragraph, found, in agreement with the two courts in respect of the delimitation of constituencies, that there was no public participation. However, in respect of Article 257(4), the role of IEBC does not extend beyond verification that the initiative is supported by at least 1 million registered voters, without going behind the process to inquire if the promoters did conduct public participation. It is the duty of the promoters to carry out public participation before or as they collect signatures. On their own volition and initiative, the promoters make a proposal to amend the Constitution. They must persuade 1 million Kenyans to vote in support of their venture, to convince the assemblies and parliament about the prospects of the initiative, and ultimately Kenyans in a national referendum. It is the promoters' burden. Was there public participation by the promoters and later by the assemblies and parliament? According to the Secretariat, according to the steering committee, both houses of parliament, some county assemblies, Honorable Odinga, there was public participation prior to and in the course of signature collection. Whether or not there was public participation is a matter of evidence. The burden of proof is always upon him who affirms and not on the one who denies. The burden was upon those who allege that there was no public participation to prove that assertion. Not a single person was presented to support the statement and to rebut the evidence in support of public participation. In support of public participation at the two levels, that is the promoters on the one hand, county assemblies and parliament on the other, there was sufficient evidence. For these reasons, I would set aside the determination of the Court of Appeal on the question of public participation. The sixth issue is on the composition and quorum of IEBC. And it is a common factor that IEBC was not fully constituted when the bill and the signatures were presented to it. Not fully constituted in the sense that it did not have its full complement. The vacancy started with the departure of Commissioner Akombe, who fled the country and announced her resignation while abroad on 18th October 2017, 16th April 2018. Commissioners Mwachanya, Dr. Kibiwot Kurgat, and Consolata Nkatha was the vice chair, held a press conference at which they announced their immediate resignation. By a Gazette notice of 14th April 2021, the President formally declared the 4 vacancies. The vacancies were not filled until September 2021, nearly 4 years from the date of those resignations, and 1 month after the decision of the Court of Appeal in this very matter. Article 250 of the Constitution is what may be called a provision of general application for the reason that it applies to all the Chapter 15 commissions. It declares that each commission shall consist of at least 3 members, but not more than 9. Section 5 of the IEBC Act has fixed the membership at 7, the chairperson and 6 members. For the conduct and regulation of business and affairs of IEBC, Section 8 of the Act refers to the second schedule, which at paragraph 5 provides for a quorum of 5 members. I've discussed in my main judgment the amendments in 2017 to this paragraph, how it was challenged in the case of Katiba, and the decision of Mwita J. I have also considered the effect of the decision in Isaiah Kibiwot Kangwon case, considered too the CKRC report on the management of elections, the Hansard recording the debate on the Election Laws Amendment Bill 2017. I have taken into consideration international best practices and borne in mind that IEBC is a body corporate with perpetual succession. The IEBC, whether full or with the minimum number of 3, is responsible for the formulation of policy and strategy, as well as providing oversight. The Secretariat and supporting units, directorates, divisions, and committees, being the professional and technical arm of the IBC, perform the day-to-day administrative functions of the Commission and implement the policies and strategies formulated by the commissioners. It is therefore a contradiction of terms for the Court of Appeal and the High Court to say in the same breath that the IBC was properly constituted with 3 commissioners but lacked quorum to transact business and conduct its affairs. I arrived at the conclusion that with 3 commissioners, the IBC was properly constituted, quorate, and competent to carry out all its constitutional and statutory duties. In the result, I would set aside the conclusion by the Court of Appeal that the IBC lacked the necessary quorum to conduct any of its business under Article 257 of the Constitution. The final framed question is on the referendum question. Whether Article 257(10) of the Constitution requires that proposed amendments to the Constitution be submitted as separate and distinct referendum questions or question was raised by Mr. Murara. Again, the details of my analysis of this issue is contained in my judgment, where I have explained in conclusion why I think the issue was premature. Noting that the draft bill had not been returned to the IBC from Parliament, IEBC had been restrained by an order of injunction from facilitating and submitting the draft bill to a referendum. The nature of a question or questions to be framed by the IBC was not ripe. In the end, the Court of Appeal erred in failing to set aside the determination of the High Court on this issue for violating the doctrine of ripeness. I would set aside the majority decision of the Court of Appeal to the effect that Article 257(10) of the Constitution requires the specific proposed amendments of the Constitution to be framed as question or questions. The details of what I've just rendered is in my main judgment. I thank you, Judge President.
Thank you, Justice Ohuko, for rendering your opinion. I will now call upon the Honorable Mr. Justice Renaura to read his opinion.
Thank you, Chief Justice, colleagues and counsel. My judgment is 149 pages. I will greatly summarize it for purposes of this delivery. And there's a presumption that all counsel can read. So please do read it, because other teachers of law tell me that counsel hardly read judgments these days. Please try and read these ones. 2, I have read the judgment of the Chief Justice and President of this court, and I will adapt it for purposes of my judgment. I also agree with their reasoning and findings, save where I shall express myself to the contrary. In that context, when the Kenyan people gave themselves the Constitution 2010, it was a matter of public knowledge that certain parts of it would require amendments at some point in the future. There was, however, no agreement as to what these parts were, and it was left to a political class to raise a number of issues over the years that debatably required amendment. Third Way Alliance, for example, initiated the Punguza Mizigo, Lighten the Burden initiative at a referendum on a number of issues. That initiative failed. I have therefore taken into account the pleadings, the submissions, and my opinion on each issue is summarized as follows. On issue number 1, I delved into the genesis and history of the basic structure doctrine. Like my colleagues before me, I looked at Kesavananda at length and the history of Kesavananda and the findings in Kesavananda. I also delved in the history of Article 257 on amendments through a popular initiative as opposed to legislative amendment under Article 256. I specifically looked through the CKRC reports, and in the final report, I reproduced sections, page 75, where the Commission said this: a distinction should be made between entrenched and non-entrenched provisions of the Constitution, with a stringent mechanism being set up for amending the former entrenched provisions, which should include supremacy of the Constitution, the Bill of Rights, land, the judiciary, security, finance, and the system of government. The final report then came up with the following recommendations. I'll only pick on 2. Recommendation number A: the new Constitution should have some entrenched provisions, for example, human rights, that Parliament does not have power to amend. And Roman D2, the entrenched provisions should include the procedure on amending the Constitution itself, the provisions establishing the Republic of Kenya, the provisions of sovereignty of the people, the provisions on supremacy of the Constitution, the Bill of Rights, the separation of powers, provisions on existence and powers of independent commissions and bodies. Those proposals by CKRC are important because, like Professor Migai Akech, amicus curiae, I have said that the above recommendations are what morphed into Chapter 16 of the 2010 Constitution, and by those provisions, the people attained the right balance between constitutional flexibility and rigidity and provided sufficient and strong safeguards against the culture of hyper-amendability that characterized the Independence Constitution. Chapter 19, in fact, of the Boas draft and Chapter 19 of the Wako draft are also identical as to what's contained in Chapter 16 of the Constitution today. History has shown us that the people did not intend to immunize the 2010 Constitution. To the contrary, they envisioned that they could amend the provisions of that Constitution through exercise of secondary constituent power, provided that the amendment procedure under Chapter 16 is strictly observed. If the people wanted to entrench provisions other than those set out under Article 255(1) or to immunize any of the provisions of the Constitution, they would have done so expressly. It is therefore correct to say that courts should not, by judicial craft or innovation, impose hurdles to prevent the people from amending the Constitution, provided that procedural requirements under Chapter 16 are complied with. In my judgment, I made reference to my own decision in Commission for the Implementation of the Constitution versus the National Assembly of Kenya and 2 others. I had counsel in this court say that that was the introduction of the basic structure doctrine by courts in Kenya. That is not anything near the truth. That judgment was addressing amendments by Parliament to Article 260 of the Constitution in order to remove the offices of members of Parliament, members of county assemblies, judges and magistrates from the list of designated officers under that article. The dispute, much like Kesavananda, related to the amendment power donated to Parliament under Article 256 and not the popular initiative processes under Article 257 as read with Article 255. In that judgment, I said, where the basic structure or design and architecture of the Constitution is under threat, this court can generally intervene to protect the Constitution. The threat was from Parliament and not the people. At the hearing of this appeal, I posed the question: what matters are outside Article 255 and which form the basic structure of our Constitution and which require exercise of the primary constituent power? I got no satisfactory answer precisely because, in fact, there are no such matters. And Article 255 speaks for itself. The issues that are ring-fenced from Parliament's amendment powers are set out in that article. I will not repeat them. These provisions cannot be implied because they're expressly provided for by this Constitution. I've also, in my judgment, separated amendments of a Constitution and constitution making. the courts below fused amendment and constitution making. If you look at what the people of Kenya did prior to 2010, civic education, public participation, constituent assembly, and the referendum, they were making a constitution. They were not amending a constitution. So that any attempt to fuse the two processes would be wrong. And I have said why in my judgment. I've also referred to other jurisdictions, to Taiwan, to Malaysia, to Singapore, to Israel. And I have said in my judgment that each country has taken a different approach on the basic structure doctrine because each country has its unique circumstances, and we must do the same. I've also looked at the Njoya case, and I've explained why the Njoya case, the circumstance it was made, the context in which it was made, and the reason why the Njoya case cannot be relevant in processes under Article 257. And going to the 4 sequential steps, I've said those processes are indeed relevant and useful, not in amendment under Chapter 16, but making of the Constitution, should we as a country ever decide again to do away with the present constitutional order and create a new one. And therefore, in summary, on issue number 1, my finding is that the basic structure doctrine does not apply in Kenya in the manner suggested by the 1st, the 5th respondents, and that the 4 sequential steps set out by the High Court and the majority of the Court of Appeal only apply when a new constitution is being made and not in any amendment process under Article 257. In addition, based on our history, the text of our Constitution, and the context as outlined in my judgment, it is legislation such as the CKRC Act 2008 and 1997 that the 4 sequential steps should be anchored when and if the people ever want to change the present constitutional order. Those are my findings on issue number 1. On issue number 2, I have read the Chief Justice's judgment. I have looked into the history of Article 257. And if you look at the CKRC reports, Article 257 was intended to be exercised by the common man and civil society, and not anyone outside that category. I have therefore no hesitation in holding that the President cannot and should not initiate amendments to the Constitution under Article 257. Like Toyota JA, I'm certain that popular initiative is people-centric, and while the President has certain rights as a citizen, there are certain other things that are curtailed by the Constitution as regards him. The President cannot initiate the process by collecting 1 million signatures and crafting an amendment bill and then retire to await the same bill under Articles 257(9) and assent to it as President. That is an absurdity that could not have been the intention of the framers. Neither can he initiate a bill under Article 256(5)(a) and then under B, request the IEC conduct within 90 days a national referendum for approval of the bill and then retire to assent to it as the President. And therefore, my finding is that he cannot initiate a popular amendment under Article 255. But I've said, knowing the politics of this country, if the President has parliamentary muscle, he can then invoke Article 256 and initiate amendments through Parliament. On the second limb of this question, I have disagreed with my colleagues. My finding is that there are 2 processes involved in this whole situation. The first process is the presidential political process, which ends with the creation of the steering committee. And then there is the process under 257(1), which is the process of the secretariat led by Junet Mohammed and Dennis Waweru. And I've said that if you look at 257 properly, the process begins with the signature collection and creation and the drafting of the bill or suggestion. And that process was only undertaken by Dennis Waweru and Junet Mohammed, and there is no place in which I have found in the record the role of the President. And therefore, on that narrow issue, I have disagreed with the Chief Justice. On the second schedule of the Constitution of Kenya, whether it's unconstitutional, I have looked at Article 89(1), and I have said you cannot, as that was done by the initiators and promoters, purport to amend Article 89(1), leave Article 89(2) to Article 89(12) untouched, and then purport to bring this amendment bill and create new constituencies without involvement of the IEBC and the people especially those who would be affected by the creation of new constituencies. Boundaries of constituencies are a very emotive question in Kenya, and that is precisely why Section 89 is very elaborate as to the procedure to be undertaken when new constituencies are being created. And therefore, for those reasons, and for the reasons given by the Chief Justice, I've agreed that that schedule is unconstitutional. But I've said something a little more. Let those who wish to create new constituencies follow the process under 89. Do not ignore IEBC, don't ignore the people, and if you wish to start the process within Section 89, Article 89, you are permitted to do that, but do not go outside the remit and permits of Article 89. That takes me to issue number 4, proceedings against the President. I agree with the Chief Justice on this question, and I've also addressed the remedy of impeachment of the President should there be a violation of the Constitution. I've also addressed my judgment in the High Court in the Isaac Aluochir case on representation of the President by the Attorney General when the President is sued in his personal name. I have said that the President cannot be sued in his personal name for violations of the Constitution, and should he be sued for whatever reason, then the proper respondent should be the Attorney General and not the President in his personal capacity. I had lawyers for the President pray for costs in favor of the President for having been properly sued in his private capacity in this case. While I agree with them that such an order would have been efficacious, in fact, the nature of this particular litigation being in the public interest, I would not grant the President orders of costs, despite my findings in his favor. On issue number 5, public participation by the IEBC and the initiators and promoters of the bill, I have looked at the BAT case, a recent decision of this court. I've also looked at Justice Pauline Nyamoya's judgment in Republic versus County Assembly of Kirinyaga, and I've agreed with the judge that in processes under 257, there are certain rules attributable to IEBC and to the initiators and promoters. Looking at the stage at which the IEBC was stopped, or the whole process was stopped, it is very difficult for me to say that public participation was not sufficient. In fact, the two most important public participation elements in a popular initiative are voter education by IEBC and popularization of the bill by the promoters. None of these processes had been reached by the time the High Court stopped the process. A last issue on this point is this. Gatembo Kairu and Tuyot raised a fundamental question. Why are we as a country still struggling with lack of a legal framework to govern processes under Article 257? There is no law on collection of signatures. There is no law verification of those signatures. There is no law on how county assemblies should pass the amendment bill, the processes by Parliament despite the standing orders, the receipt of the bill by the President, transmission of the bill to the President, the referendum. I have said it is about time to avoid the confusion that I'll address shortly as I address issue number 6 and 7, that we need a law. And so I agree with Justice Tuyot and Justice Kairu that this law is absolutely necessary. And therefore, the second schedule, in my mind, is an exception. The public participation processes were properly undertaken, save for the second schedule, where I have said that it's unconstitutional for the reasons that I've given. Articles 88 and 250 with regard to composition and quorum of the IEBC. I have looked in my judgment at the Katiba case by Chacha Mwita J. I have looked at the Isaiah Biwott case by Frida Okwan J. I have looked at Article 250, sub-Article 1. I have taken into account the very lucid submissions by Esther Angawa regarding Article 88.5, and I have said that, to my mind, looking at the law as I understand it, IEBC was correct at all material times, its processes were lawful, and therefore a contrary finding would, in my view, be in error. There was a second issue raised by Ms. Kituku regarding nullification of the laws. Well argued as the point was, and lucid as the arguments were, I've declined the invitation to address that question, because once I found IEBC correct, other matters are irrelevant. The last issue is issue number 7 on the proposals whether proposed amendments should be submitted as separate and distinct referendum questions. Like the Chief Justice, I have looked at the law of ripeness and mootness. I have looked at the law on justiciability, and I have come to the firm conclusion, like Justice Tuyot, that this question was premature. IEBC had not had the opportunity to exercise its mandate as the body to conduct the referendum, to draft the question or questions, and I've said only this as regards that mandate. Section 49 of the Elections Act and Article 257 do not sit well together. And I've asked IEBC to, as they reconsider this question, to look at Section 49 of the Act and Article 257, harmonize the language. I've shown why, in my judgment, why there's a problem with that issue. And only then would any party with a dispute go to court once the IEBC has determined the matter within its mandate. Once courts start taking off the mandates of independent commissions, we shall walk into a minefield. And therefore, in conclusion, summary of my findings are as follows. On the basic structure is my finding that the doctrine as enunciated in the Casavanada case has not attained wide acceptability and cannot certainly be applicable to Kenya, noting our history, context, and constitutional text. The 4 sequential steps identified by the High Court as necessary in an amendment process are also not applicable, save in the creation of a new constitutional order, which is not the case in this dispute. Number 2, on whether the President can initiate a popular initiative to amend the Constitution Article 257, it is my finding that he cannot. But I've said also that in this particular dispute, he did not. On whether the second schedule of the Constitution is unconstitutional and purported to limit boundaries without the input of IBC, without amending Article 89, 1 to 12, without involving affected persons and the public at large, I have held that it is indeed unconstitutional. Can civil proceedings be instituted against the President during the term of office? I have said no. And should he be sued, then the proceedings should be against the Attorney General, and any remedy for a suit directly against the President should lie in costs awardable to the President. On public participation, at the time the High Court stopped the process, I cannot find reason to fault either IEBC or the initiators and promoters, with the exception of the second schedule, which I found to be unconstitutional for inter alia lack of public participation. On the quorum of IEBC at all material times, I find that IEBC was correct and all its undertakings were lawful. On the question whether a referendum, single multiple questions should put the people by IEBC, I find the matter was premature and was not ripe for determination. On costs, the public interest exhibited in this matter will lead me to the conclusion that each party should bear its costs. My reasons in detail are contained in my judgment, which you shall get copies of. I thank you, Chief Justice. I thank you, Counsel.
Thank you, Honorable Mr. Justice Renaura, for rendering your opinion. I will now call upon Lady Justice Jokindongo to deliver her opinion.
Thank you very much, Chief Justice. I will proceed to summarize my judgment. On some issues I will be brief, others I will interrogate them a little bit more. Issue number 1, is the basic structure doctrine applicable in Kenya? In order to determine whether the basic structure doctrine is applicable in Kenya, there is need to define the term doctrine under international law and establish whether the basic structure doctrine is indeed such a doctrine and if it is applicable here. I recognize that there are differing opinions on the definition of a legal doctrine, but to my mind, the basic structure doctrine as presented by the parties to us is a judge-made law emanating from the municipal court, which is the Supreme Court in India, in the Casavananda case. That basic structure doctrine has been upheld and relied on in subsequent decisions in India, and I note that there are few jurisdictions around the world where basic structure doctrine has been applied, while in others it has been rejected. It is my considered view that the basic structure doctrine as presented by the parties does not constitute a widely adhered to a legal doctrine. It is my observation that the basic structure doctrine has been both applied and rejected I've listed the countries in which that has happened, and therefore it is my considered opinion that the states only constitute a very small percentage of countries in the world that have attempted to apply or have applied the doctrine. Furthermore, there have been no pronouncements made at the international level, no international case law on the same. The only available cases are from domestic courts at national jurisdiction, and therefore it cannot be said that the basic structure doctrine has attained the status of a general principle under international law, and it cannot be applied by this court as a general rule of international law as contemplated on Article 2(5) of the Constitution of Kenya 10. The above notwithstanding, is the basic structure doctrine as presented by the parties applicable in Kenya? It is my considered opinion the answer to this question can only be deduced by our constitutional past. Kenyans stressed the fact that they needed a constitution that had entrenched provisions on certain aspects, was not too simple to amend, and one that required their participation in terms of amendment. The final report of the Constitution of Kenya Review Commission captures these sentiments where the people's voice is summarized. And these sentiments made it into our current constitution, where Chapter 16 of the Constitution is unequivocal on how to amend the Constitution. It is therefore my position that it was the intention of the drafters of the Constitution to protect or entrench the specified 10 matters in Article 255(1) by stipulating their specific amendment procedures. If the drafters of the Constitution intended to entrench or protect any other provisions or deem them eternal or unamendable, they would have expressly done so. On my part, I do not consider any article in the Constitution unamendable or constituting eternity clauses. A textual reading of the Constitution confirms this view. It is evident, therefore, that the Constitution itself expressly provides an inbuilt amendment procedure for any anticipated amendments. Consequently, it is unnecessary to import the so-called basic structure doctrine into Kenya. I briefly turn to the issue of constituent power, and I find that the constituent power is a power that cannot be limited by any pre-existing rules, even if such rules purport to regulate replacement of the current constitution. It is also my finding that the 4 sequential steps are not expressly provided for and cannot be inferred from Article 257 of the Constitution. As such, those steps cannot be a mandatory requirement when there is no law providing for the same. Moving on to the next issue, as to whether the President can initiate changes or amendments to the Constitution. The Court of Appeal upheld the High Court's finding that the President, for as long as he held office, could not, as an ordinary citizen, move constitutional amendments through a popular initiative on the ground that the same route is intended for ordinary citizens. The appellate judges found that the amendment bill was not a popular initiative, considering that the process that culminated in the same was a process that was led and driven by the executive, the political elite, as opposed to the people of Kenya. Some respondents have urged that the proposals by the BBI task force could have been taken up by anyone else, by any promoter, but not the President himself. Having perused carefully through the judgments of the superior courts and also through the Constitution of Kenya, I find this proposition is untenable for several reasons which I shall expound upon. However, before I expound on my views, I must state I'm rather disturbed and concerned by the way the superior courts framed their issues for determination. The High Court framed its issue 3 for determination and used words not in the constitutional text, attached meaning to them, and made determination on them. At paragraph 388 of its judgment, the High Court framed the issue as follows. What is the constitutional remit of amendment of the Constitution through a popular initiative? This issue further twins into 2 sub-issues. Who can initiate a popular initiative under our constitutional setup? And 2, the BBI process, is the BBI process of initiating amendments to the Constitution in conformity with the legal and constitutional requirements? And 5, was the President in contravention of Article 73(1) of the Constitution for claiming authority and purporting to initiate constitutional changes through BBI? Similarly, at the Court of Appeal, Musinga, President of the Court of Appeal, listed the following issue for determination: whether the President of Kenya can initiate the process of amendment of the Constitution as a popular initiative, and who the initiators and the promoters of BBI initiative were. The learned judges of appeal unanimously agreed with the High Court that the BBI amendment process under Article 257 of the Constitution was intended for ordinary citizens. Further, they stated that this is a citizen-conceived, citizen-initiated, and citizen-driven process. A lot of time and attention was dedicated to the meaning of certain words. This would not be problematic if these words were found within the body of the Constitution to interpret an appropriate meaning to them. However, interpretation of words not in the Constitution bring confusion. In my view, a constitutional court must confine itself to interpretation of the letter of the Constitution, and if any word or phrase is read in, it must be clear that this is the rule of interpretation at play. The words I'm concerned about include initiate and initiator, citizen-initiated, and private citizen. None of these words appear in Articles 255 to 257 of the Constitution. The High Court in particular went on a spirited approach to expound on these terms and paid little attention to the words that actually appear in Chapter 16 of the Constitution, which are the words promoter, popular, and initiative. In my opinion, the learned judges introduced a non-constitutional actor called an initiator, who performs a non-constitutional action, initiate, when the Constitution only provides for a promoter whose definition is vastly different from an initiator. As such, the emphasis was laid on the actor-initiator. This, in my opinion, fundamentally changed the import and meaning of Article 257 of the Constitution, and I am of the opinion that the correct approach should have been to define what a popular initiative is and who can be or who is a promoter of a popular initiative. The Superior Courts ignored the fact that the drafters of the Constitution used certain words and went in to read in words whose effect is to change the entire meaning of the constitutional text. The tool of reading in is only applied where the framers have left out a word or phrase from a provision. Further, this reading in must be supported by other connected provisions of the Constitution. I perused carefully all the judgments, looking for proper reasons for the decision to exclude the President from the amendment process, and I cannot find a logical, constitutionally based explanation for the conclusions and findings of the Superior Courts on this question. I can only term it as interpretational misadventure, if not judicial constitutional overreach or judicial invention. As such, the learned judges erred fundamentally on this, and in my considered view, which I shall now expound on, I will specifically look at the constitutional amendment process as provided for in Chapter 16, the interpretation of constitutional silences, the exercise of the authority of the people under Article 1, the authority of the President under Article 131 and 132 and 141(3), and the political rights under Article 38. The Constitution 2010 provides for two processes through which it can be amended. These are the parliamentary initiative and the popular initiative. For the popular initiative, promoters, after collecting the signatures of at least 1 million voters, submit the signatures and the bill to IBC, who sends the bill to the counties. The bill must then be approved by a majority of the county assemblies, and then approved by a majority of the houses of parliament. And if Parliament passes the bill, it is submitted to the President for assent. It then goes to referendum where the majority of voters must support it. Article 257 does not define popular initiative. Nevertheless, I am of the opinion that at the heart of construing the meaning of popular initiative, it lies with the numbers. It is proper to lay emphasis on the numerical value of at least 1 million registered voters who have to sign, the numerical value of at least half of the counties who have to vote to support, the numerical value of 2/3 of the votes in both houses in Parliament, and the numerical value of half the votes cast by registered voters at the referendum. It is the numbers that count. It is the numbers threshold that the promoter must meet. It is the numbers that makes the initiative popular. In the context of Article 257 of the Constitution, a promoter needs at least 1 million registered voters to support their proposals. That's what triggers the IEBC verification process. It is therefore my considered view that the popular initiative is primarily about numbers that the promoter must attain and not about who the promoter is or who the person who brings the amendment is. As such, the Superior Courts made a fundamental error by determining that popular, the word popular relates to who moves the amendment and not numerical threshold that the promoter has to attain. So, for example, in 2016, the court of Kenya Bill were not able to achieve the 1 million signatures, and it collapsed through the operation of the law. It is important to note also that Section 257 does not in any way specify who may move a constitutional amendment process by popular initiative. It does not contain an explicit bar against any person promoting a constitutional amendment by popular initiative. It specifically provides what actions the promoters are tasked with in order to begin and complete an amendment process, but it does not state who the promoters must be. The unsaid is influential in constitutional law. Some matters of constitutional relevance sometimes are left unaddressed. Sometimes, knowingly or unknowingly, the drafters of the Constitution may underappreciate how much power rests in the silence around the text. Constitutional silences are functional and inevitable, and enabled by a lack of very strict textual restraints, constitutions have the capacity to grow with time, experience, societal needs, and changes, thus allowing successful constitutions to thrive. This Supreme Court has played a crucial role in interpreting silences in the Constitution, but it must be cautious, though, so as to avoid judicial legislation. This court must interpret silences judiciously. Taking recourse to this doctrine, therefore, how do we interpret the silence as to who can originate a popular initiative amendment? In my considered view, the first step leads us directly to the constitutional text itself. Article 1 of the Constitution is categorical, that all sovereign power belongs to the people of Kenya and shall be exercised in accordance with the Constitution. Further, in that article, sovereign power may be exercised either directly or through their democratic elected representatives. The National Executive enjoys delegated sovereign power under Clause 3 of Article 1 of the Constitution, and according to Article 36(1) of the Constitution, the President shall be elected by registered voters in a national election conducted in accordance with the Constitution. In addition, Article 1 of the Constitution elaborates the tenets of a functioning republic, anchored in the concept of libertas populi, which defines the characteristics of a functioning republic. It envisions a system that has responsible citizens who exercise their rights democratically and consciously. A free res publica is the highest value of all for citizens. Article 1 preserves the exercise of the actual legal authority or power, which is exercised by the people directly or through their democratically elected representatives. From the foregoing, there is no doubt that the President is a democratically elected representative of the people who, under Article 1, can exercise delegated sovereign power of the people. Indeed, this is one of the ways in which constituent power is exercised under our Constitution, and therefore, I am confounded by the fact that the superior courts address the constitutional power of the people at length, but for whatever reason, fail to take into account that the President is a directly elected representative of the people, and he can exercise delegated power on their behalf. Furthermore, it is a fundamental right of the Kenyan people to elect their representatives, and that those so elected to speak on their behalf. To limit the ability of an elected representative to speak, to act, to work on behalf of his or her electorate is itself a limitation of the people's political rights under Article 38 of the Constitution. Such proposition would amount to limited republicanism, limiting the extent to which people exercise their powers either directly or through their elected representatives. More poignantly, However, limiting the powers of the people donated to the elected representatives reorganizes the architecture of the Constitution's order of delegated governance. It is not in dispute that the President bears an elevated status by virtue of his office. The President has additional roles and obligations in comparison to the ordinary Kenyan. In addition, Article 132 of the Constitution mandates the President to safeguard the sovereignty of the public, promote and enhance unity of the nation, promote and respect the diversity of the people and communities of Kenya, and ensure the protection of human rights and fundamental freedoms and the rule of law. Article 132(1)(c) of the Constitution stipulates one of the many mandatory functions of the President. The President must, once every year, report in an address to the nation on all measures taken and progress achieved in the realization of the national values referred to in Article 10. In my considered view, the President is not limited as to those measures he can take to undertake he is not limited as to the measures he can undertake in the exercise of his functions under Article 132. The said measures could constitute a policy, statutory, or constitutional frame. Clearly, in promoting and enhancing national unity, the President can promote constitutional amendments through popular initiative. This would qualify as a measure taken under Article 132 on which progress achieved can be reported. It is directly within the four corners of the Constitution of Kenya. I am convinced that when the President takes measures in the exercise of his functions, including a proposal for the amendment of the Constitution, he is bound by the oath prescribed by the Constitution and which he swears when he takes office to act in the best interests of Kenyans and not to undermine democracy. One need not worry about the President overstepping because the parameters in the Constitution are sufficient to rein him in. How can I claim this so boldly? This is informed by our constitutional history. When one looks at the history of constitution making in this country, it is clear that one of the intentions of the drafters of the Constitution was to discard parliamentary monopoly over the constitutional amendment process and to make it more inclusive. Kenya's journey to democratic constitution was arduous, taking into account that most of the amendments taking into account most of the constitutional amendments made in the first President Kenyatta's era. In the first President Kenyatta's 15-year reign, he oversaw 16 amendments. President Moi, in his 24-year presidency, oversaw 14 constitutional amendments. Both presidents were members of parliament and used parliament to amend the constitution in a manner that excluded participatory democracy. The people were not involved in any way. By 1992, and because of this, all key institutions, the judiciary, parliament, public services, security forces, and the provincial administration were instruments of authoritarian control. Concentration of power in the President was one of the factors that prompted demands for a new constitution, and the 2010 constitution aimed to curb dictatorship by parliament in the amendment process. Kenyans wanted to have a head of state who would not whimsically amend the constitution. They wanted to limit the powers of the constitutional amendment by the head of state, but not to take it away altogether. In other words, the intention was to make it difficult, but not impossible, for a president to make a constitutional amendment. This is the mischief that the framers of the Constitution sought to address. In my considered view, therefore, there is no historical evidence that the drafters of the Constitution intended that the President be excluded from the popular initiative amendment route or that it be limited to a specific class of people to the exclusion of others. If anything, the resultant very expansive Chapter 4 on the Bill of Rights in the Constitution of Kenya 2010 proves otherwise. The President enjoys all constitutional rights and freedoms like any other Kenyan. He is first and foremost a Kenyan citizen by birth. A president does not lose his or her political rights under Article 38. He or she does not cease to be a registered voter by virtue of ascendancy to presidency. There is no law pursuant to Article 24 of the Constitution, which is the limitation clause, that limits the president from enjoying political rights under Article 38, especially that of campaigning for political cause, which in my view includes constitutional amendments. In addition, trusting citizens with public office does not in any way muzzle them or take away their rights, as provided in the Bill of Rights. Article 27(1) of the Constitution provides that every person is equal before the law and has the right to equal protection and equal benefit of the law. Additionally, equality includes the full and equal enjoyment of all rights and fundamental freedoms, and the President, like all Kenyans, is obligated to respect, uphold, and safeguard the Constitution. If any Kenyan has the right to initiate a popular amendment to the Constitution while respecting, upholding, and defending the Constitution, so too does the President in his official or personal capacity. It would be restrictive, unjust, unprogressive, and unconstitutional to limit that right. At this juncture, I find it prudent to comment on the submissions that the President is excluded from promoting changes to the Constitution by popular initiative because he can do so through Parliament. According to Article 256 of the Constitution can only be amended through a parliamentary initiative. Under Article 256 of the Constitution is silent as to who can introduce a bill into either of the Houses of Parliament. However, the composition of Parliament is clear, and the membership of the National Assembly is provided for under Article 97(1), and that of Senate under Article 98(1). The President is excluded as a member of Parliament. In other words, the President is not a member of Parliament, and by parity of reason, he cannot introduce a constitutional amendment through a parliamentary initiative. Apart from making the finding that the President cannot initiate constitutional changes, the Superior Courts also found that state organs similarly cannot initiate such changes. However, it is important to note that all state organs and state officers form part of the national executive, county governments, the legislature, the judiciary, independent commissions, and independent offices. Accordingly, then, all holders of such offices under Article 1 also exercise delegated power from the people and must perform their functions in accordance with the Constitution. If those functions require measures or policy actions that would require constitutional changes, then they must be able to use their delegated authority to exercise those functions. To suggest otherwise would result in an absurdity. For example, let us assume the Chief Justice, as the chair of the Judicial Service Commission, wishes to make proposals on judicial reforms. And she puts together a draft bill and presents it to the IEBC as a promoter. If we are to follow the findings of the Superior Courts, the Chief Justice would find herself barred from proceeding. However, if her Chief of Staff or the Deputy Chief Registrar were to take the same document, it would be acceptable. Similarly, if the Speaker, as the chair of the Parliamentary Service Commission, wished to make some proposals, constitutional proposals around parliamentary reform, the judgment of the Superior Courts would prevent him from taking such amendments himself, although the clerk of the National Assembly and the head of the legal department in Parliament can do so. The result is leadership without authority. In a democratic government, it is an untenable absurdity. In conclusion, I'd like to say on this point, a popular initiative amendment is not a preserve of specific persons. Any Kenyan can originate and promote the popular initiative amendment, and the people, as defined in the Constitution, also mean their representatives exercising donated sovereignty. As such, it remains an inclusive process and not a process that excludes and that empowers every person to propose constitutional amendments. Having found that the President and the state organs can promote a popular initiative, who then was the real promoter in the impugned bill in the dispute before us? A perusal of volume 34, page 226 of Morara Omoke's Record of Appeal reveals the replying affidavit of Dennis Wawero, whereby he swears that he and Junet Mohammed are the co-chairpersons of the Building Bridges to a United Kenya, created and mandated with the task of initiating a constitutional amendment process and unifying Kenyans, among other things. From the record, IEBC's press release acknowledges the receipt of the Constitution Amendment Bill 2020 and the 4.4 million supported signatures. There is also a letter from IEBC which specifically talks of the promoters as Dennis Wawero and Junet Mohammed. It is therefore my conclusion that the promoters referred to in this bill are Dennis Wawero and Junet Mohammed. The record speaks for itself. Further, having perused the Constitution of Kenya Amendment Bill 2020 in Annexure B of the report of the Steering Committee of the Implementation of Building Bridges to a United Kenya Task Force report of October 2020, and the Constitution of Kenya Amendment Bill 2020 dated November 25, 2020, and the promoters' bill that was forwarded to county assemblies and parliament, I make observations that the bills are vastly different in terms of content and proposed amendments. For instance, while the Steering Committee Annexure Bill does not propose amendments to Articles 82, 89, 1, 96.3, 115.4, 168, 188.1, 204, 206, 207, 228, and 250 of the Constitution, the promoters' bill does. The bill as presented by the promoters to the IEBC does not contain some of the amendments contained in the Steering Committee bill, namely amendments to Articles 91, 200, and the repeal and replacement of Article 218, insertion of 218A, amendments to Articles 221, 223, and the repeal and replacement of Articles 246. In addition, there are new Articles 108A, 153A, 206A, which only appear in the promoters' bill and do not appear in the committee steering bill. There are also major differences in the preambles, in the first and second schedule, which are substantially different. So there are two different documents. None of the superior courts examined these facts, leading them to the erroneous conclusion that the BBI Steering Committee, the BBI Task Force, and the promoters were one and the same. Neither Junet Mohammed or Dennis Wawere were part of the BBI Steering Committee or the BBI Task Force, both of which were gazetted by the President. They are similarly named initiative of which their part has no legal nexus with the two gazetted entities. It is clear in correspondence between IEBC and the promoters that they engaged the IEBC as individuals and were not representing any entity, including the President. As I conclude on this issue, I fault the superior courts for making declarations of unconstitutionality without specifically itemizing the article of the Constitution that was either denied, violated, infringed, or threatened. For instance, the superior courts found the BBI process of initiating amendments to the Constitution unconstitutional. Which specific article of the Constitution it offended or threatened, it is still unclear. The superior courts ought to have dissected the issue to specific actions that were taken against the constitutional provisions against which they could be measured. Instead, it would appear that the focus was on actions, actors, and processes which are not within the constitutional ambit, and in particular, which are not to be found under Article 257 of the Constitution. In summary, my finding on the issue is the President did not initiate the amendment process in dispute. He was not the promoter of the popular initiative under 257. I now move to the third issue, which is whether the second schedule to the Constitution of Kenya bill is unconstitutional. Before ascertaining the unconstitutionality of the second schedule, it is important to interrogate the legal standing of the impugned bill. In Black's Law Dictionary, a bill is defined as a legislative proposal offered for debate before enactment. Article 109 of the Constitution says that Parliament shall exercise its legislative power through bills passed by Parliament and assented by the President. In addition, Article 116 of the Constitution talks about the coming into force of laws and speaks of the bill passed by Parliament, assented by the President, shall be published in the Kenya Gazette as an Act of Parliament within 7 days after assent. Accordingly, a bill does not become law until it is passed by the legislature, and the President completes the legislative process by formally assenting or giving his consent to the bill. Articles 2, 4, and 165 of the Constitution contemplate scenarios where laws are unconstitutional and can be declared so. The Constitution does not provide for pre-enactment mechanisms to determine whether a bill is constitutional or not. So in this instant matter, the judges of the Court of Appeal did declare the second schedule of the Constitution unconstitutional, but considering that the Constitution Amendment Bill had not yet been promulgated into law, I find fault with the Superior Court's finding on the basis that they did not have jurisdiction to interrogate the constitutionality of a bill before it's been passed into law. I reiterate, it's only after a bill has been enacted and attained the status of a law that the courts acquire jurisdiction to entertain the same. But before a bill is enacted into law or an act of parliament, the courts don't have jurisdiction to determine the same for lack of ripeness. Now, having found that there's the issue of lack of ripeness, what can this court do? Can it proceed to address the same? And if so, under what circumstances? In the case of Aramat, this court did state that this court's jurisdiction is to develop rich jurisprudence that develops and respects Kenya's history and traditions and facilitates its social and economic growth, and that the Supreme Court is the guardian of the Constitution and the final arbiter. And the same principle was stated in the matter of Speaker of Senate and several other cases of this court. In light, and I've laid out the decisions, in light of all those decisions above, it is my considered view that the issue before us is one that cannot be ignored. However, there needs to be a test to assess whether indeed, despite the lack of ripeness, whether this court can actually issue for judicial determination. And secondly, assess the hardship to the parties and the general public if judicial relief would be denied at this stage. In other words, is this the kind of question that can be determined only when ripe without occasioning any hardship to the parties or general public? I've then laid out a number of cases and writings around the fitness test on issues of ripeness and how one can assess whether an issue is fit despite the issue of ripeness. I do find, having laid out the issues around the test, I do find that in this particular situation, that this court can apply the test and we can address the issues despite the lack of ripeness surrounding the bill. Thus, I have perused the second schedule to the Constitution of Kenya Amendment Bill and noted that it seeks to introduce an amendment to Article 89(1). However, the schedule that is attached then purports to amend Articles 81, 2, 3, 4, 5, and 6, but it purports to do this on its own without an accompanying proposed amendment to that section. In the UK Court of Appeal decision, Mohan versus Her Majesty's Senior Coroner for Oxfordshire, Lady Arden observed the follows. It would be contrary to drafting conventions for a schedule to be used to make what should clearly be what has a change or what will have some change or of consequence in the law. It is improper for a schedule to have matters of principle, and nothing should be placed in a schedule to which the attention of Parliament should be particularly directed. Flowing from the above, I am persuaded that the second schedule to the Constitution Amendment Bill, even if it were to be enacted into law, cannot amend Article 89 of the Constitution. It would be contrary to drafting conventions if the schedule of the Constitution was to propose an amendment to a substantive article of the Constitution on its own. What ought to have happened is that there needed to have been a standalone provision that brought the substantive amendments to Articles 89.2, 3, 4, 5, 6, 7, and 8. Therefore, the second schedule to the Constitutional Amendment Bill conflicts with the substantive provisions of Article 89 of the Constitution, and it is therefore unconstitutional. On issue number 4, on whether the President can be sued for performing functions of his office, I will be brief. The rationale for presidential immunity comes from the enormous responsibility bestowed upon a president as a single source of executive power. Therefore, immunity from legal proceedings is designed to permit a president to just discharge his obligations with as much autonomy as possible without anxiety that court proceedings would probably disturb, humiliate, or encumber him from focusing on his duties. This protection is also envisioned to shield the dignity of the office of the president and not him personally, particularly because he makes far-reaching and sensitive decisions. I've considered the parties' pleadings and submissions, and it's obvious that the point of diversions is whether or not the president is immune from constitutional violations during his tenure of office. It is not contested that the president appointed the Building Bridges, the BBI task force, to document and recommend practical administrative reform processes that will build the country's long-lasting unity and implement modalities for each identified area. The president has a unique position in the constitutional scheme, and as already discussed in issue number 2, he has a responsibility to promote and enhance the unity of the nation. It is my finding, therefore, that if the president, no, I'm sorry, that's not where I want to go. It is my finding that the president, in appointing the BBI task force, was discharging his constitutional mandate, promoting and enhancing the unity of Kenya, and consequently, there was no basis for concluding that the president's actions contravene the Constitution to deprive him of immunity provided for under Article 143 of the Constitution. There is no evidence tabled before the trial court to dispute this, and that his actions were not within the four corners of his constitutional mandate of promoting and uniting the country. One may ask what recourse is available to a party who is aggrieved by the presidential actions or omissions that grossly violates the Constitution and is outside his constitutional function. And Article 145 provides any member of the National Assembly, supported with at least 1/3 of members, the ability to move a motion of impeachment. And that is how to deal with it. To this end, I do disagree with Justice Tuyot on his conclusion that Article 132 leaves it open for the president to be held personally liable once out of office for any act or omission not done in office. And my finding is that the president's actions or omissions entitle him to immunity as provided for in under 143 of the Constitution. I'll move quickly to the next issue, which is public participation. And this is what I'll say. To determine whether the Constitutional Amendment Bill 2020 was subjected to public participation within the parameters of Article 257 of the Constitution, we need to examine the steps and inbuilt mechanisms that are provided for therein. In my opinion, the steps are as follows: the submission of the bill and the minimum 1 million signature of registered voters. Then the verification of signatures by IBC. Then the consideration of county assemblies. Then the consideration of the House of Parliament, and then the referendum. So when we go to the first step, Mr. Omoke urged us that the promoters ought to have conducted public participation prior to the collection of signatures. But on this, it is my finding that the collection of signatures is not a constitutional process under Chapter 16 of the under Chapter 16. And the promoters are not under any obligation to conduct public participation prior to the collection of signatures. In order to assess whether the public participation has been conducted in accordance with the specific provision of the Constitution, the test which a court ought to apply is against a particular provision. So to my mind, Article 257 of the Constitution does not first provide for the collection of signatures, but for the submission of a bill with at least 1 million signatures. This, in my opinion, is the first step. And then second, it does not make provision for public participation during the collection of signatures. Having found that Article 257 does not expressly provide for public participation during the collection of signatures, the standard to apply when assessing the same, if any, will be lower than the law, than where the law is expressly provided for public participation. I am unable to agree with the Court of Appeal's findings that there was a constitutional requirement to conduct public civic education at the point of collection of signatures. And I cannot concur with Nambuye's finding that there was need to give the public the reports, the bill in Kiswahili, Braille, sign language before the referendum. Having found that the constitutional amendment process commences with the submission of signatures and that the Constitution is silent on pre-bill procedures, it is my considered opinion that the promoters were not required to take public participation at this juncture. From the foregoing, it is my presumption that when a supporter signs in support of the draft bill, then such a supporter must have read, understood, and agreed to the proposed amendments, asked questions about any unclear. It therefore goes without saying that the promoter, before urging the support of his or her proposal, must talk to people or must have made his bill understood by the people. I disagree that there was no, I disagree with the court's conclusion that there was no public participation during the collection of signatures. And moving on to the next step is to consider whether there was public participation at the county assemblies. I take judicial notice that in compliance with the Constitution and the County Governments Act, county assemblies have standing orders with set guidelines on public participation. And in that regard, a bill in the County Assembly, having been read for the first time, is committed to the relevant select committee, where it takes into account views and recommendations from the public and reports back to the County Assembly. I've looked at the record, and it's my conclusion that none of the petitioners before the High Court specifically alleged that any of the county assemblies failed to conduct a public participation as per the standing orders. Similarly, there is a similar process before the two houses of parliament, and there is no evidence that this public participation did not take place. It is my finding, therefore, that there was public participation at the county level and at the houses of parliament. The final step in assessing public participation under Article 257 is at the referendum stage, but we had not reached there. Lastly, on this question of public participation, I believe it is time for the legislature to urgently provide for the parameters of public participation. I recommend it does so through a statutory enabling framework. Such legislation should provide precision and clarity on the various processes involved and address issues like mode, extent, stages, proof of public participation, funding, responsibilities of who does what and when. Does the IBC have the requisite quorum to conduct business? It is my finding that it does. And I'm sorry. And I have then come to the two conflicting decisions in the High Court, which were raised by parties. It is my considered view that even though horizontal stare decisis is not binding on courts of equal jurisdiction, the trial courts need to follow the decision of other judges of the same court unless there are compelling reasons to depart from the same. This is to ensure consistency, certainty, predictability, and sound judicial administration. In this context, having found that paragraph 5 of the second schedule of IBC Act is constitutional, It is my finding that it was justified for the trial court in the Isaiah Biwott case to depart from the Katiba case. Furthermore, in this present case, I'm not persuaded that there existed compelling reasons to warrant the trial court in this case to depart from the Isaiah Biwott case. I have then laid out my reasoning around retrospective unconstitutionality and prospective unconstitutionality, and I think that I will leave that for parties to read when they read my full judgment. Finally, on the last issue, I do agree that the issue is not ripe, like the Chief Justice has stated. However, once again, the fitness and hardship test, which I developed when I was writing issue number 2, I think does apply, and I have made findings that there can only be one question at referendum, and that the provisions of Section 49 are unconstitutional. They are unconstitutional. Thank you very much.
Thank you very much, the Honorable Justice Joaquin Dongo, for rendering your opinion. It is now my pleasure to invite the Honorable Mr. Justice Wanjara to deliver his opinion.
Thank you, Chief Justice and President of this court. Mine is a summarized delivery of my judgment, because I know that, I expect counsel to read the judgment. But even if you don't read, I know that out there are Kenyans who will read it and contribute to the growth of jurisprudence in our country. And so I begin by also acknowledging the fact that I have perused the lead judgment by the President of the court, and I'm in agreement with how the contents of the background have been captured and the submissions by the parties have been paraphrased. And so this enables me to immediately go into the consideration of the 7 issues that we formulated for ourselves with your concurrence. But before I do that, I must also pay my gratitude to our colleagues at the High Court and the Court of Appeal for their gallantry and industry which they invested in this enterprise. It's due to those efforts that at this stage I can say we now find ourselves in the fog of the season's end, for those of you who read beyond the legal text. And now to the first question, whether the basic structure doctrine is applicable in Kenya, and if so, to what extent? And I begin by acknowledging the fact that never since the promulgation of the Constitution of 2010 have our courts been confronted by so polemical, elastic, and indeterminate notion as the so-called basic structure doctrine. And it all began with when a group of distinguished citizens, aggrieved by what they perceived was an imminent overthrow of the Constitution, approached the court, the High Court in particular, seeking its intervention to stop that overthrow. And I've also, like my colleagues, traced the origin of now what is being called the basic structure doctrine. And I don't think I need to go into the stages, the historical stages of how this notion, in my view, sprouted and continues sprouting in parts of the world. I think that my colleagues who have spoken have done a sterling job, and I do not intend to retrace the history of this doctrine. But I do ask, how did we find ourselves enmeshed in this kind of theorizing? Because right from the High Court and now up to this court, what we appear to be doing when addressing this notion of the basic structure of the Constitution is really a preserve of legal and social science scholars. It is hardly an occupation of a court of law, not to mention an apex court of law like this one. So how did we find ourselves in this process? Is because there can be no doubt that in approaching the court, the petitioners had been aggrieved by what they perceived as an imminent threat to the Constitution posed by this amendment bill. But instead, what they should have done, in my view, they would have laid down a prayer in which the alleged the fear of violation of the Constitution, and in support thereof, they were at liberty to deploy any arguments, propositions, and analytic tools to convince the court that indeed such a declaration was warranted. But instead, what we have here is a fundamental departure from a long-established tradition of invoking the jurisdiction of the High Court. The petitioners instead presented the court with a theoretical construct, a fait accompli, whose declaratory validation they sought. And unfortunately, the High Court elevated this proposition as designed by the petitioners into an issue for determination, even at a preliminary level. And later they would be joined by our colleagues at the High Court. But be that as it may, now that the applicability of the basic structure doctrine in courts has snowballed into a ubiquitous inquiry, we at the Supreme Court may not, without stirring justified indignation, disregard it altogether. And so I have been compelled, just as my colleagues have been, to go into an exegesis of what then is the anatomy of this basic structure doctrine. I have asked myself whether indeed it is a doctrine, juristically speaking. I have come to the conclusion, after not just a soul searching, but serious thoughts, that what we are faced with as a basic structure doctrine is no such doctrine. Instead, it is what I consider as a school of thought, or at best, a heuristic device, which a court of law, when faced with the question as to whether a proposed constitutional amendment is of such a nature as to destroy, destabilize, or distort the constitutive authority of the Constitution, a court of law faced with such kind of question can deploy this heuristic device in its effort to answer the question. But I find no fault with this rich and diverse array of opinions, so eruditely crafted by some of our finest in the judicial system, the legal profession, academic institutions, and from far afield by way of amici curiae. And indeed, we who are called upon to adjudicate upon the affairs of men and women in their relations with one another and between them and the state are all the more privileged when served from such a tantalizing menu of ideas by the bar and the bench. Yet my discomfiture, ladies and gentlemen, with the manner in which this issue was brought before the High Court in the first instance still persists. And it bears repeating that in the ordinary scheme of things, a petitioner ought to approach the courts seeking relief on the basis of a real or perceived violation of the Constitution. But to begin by seeking a declaration that there exists somewhere in our psyche, beyond and above the Constitution, a doctrine that is nonetheless applicable in our legal system and which we have to take cognizance of even as we embark upon the determination of whether certain actions or omissions have violated the Constitution, is to lead judges onto a terrain hitherto uncharted. It is my firm view that this prolonged debate has been agonizingly stripped of the discipline of judicial inquiry, first through what I consider to be the conceptual profligacy of elevating a notion to a legal doctrine and embellishing it with an extra-constitutional force of law, and then quite inexplicably attempting to locate the minted doctrine into the text of our Constitution. So on the one hand, we are treated to what I can call lyrics of contextualism, while on the other we are strung with thirds of textualism. And so the orchestra, in my view, goes on, which, if not choreographed, could unleash an interpretative odyssey, or maelstrom, if you like, attempts to wriggle therefrom by those to come after us, which could end up in theatrical ignominy. All this while, scant attention has been paid to what I consider a majestic directive principle in our Constitution, a tool of analysis that, faced with such questions as the ones I have posed, a court of law must deploy. And I make reference to Article 259 of the Constitution, the marginal note of which reads, construing the Constitution, or construing this Constitution. And instructively, this provision is preceded by another, which I consider as a defensive armor gifted to our vigilantes of democracy and the rule of law. And this is Article 258(1). And so I go on and on that by the end of the day, in answer to the issue as so formulated, I arrive at a conclusion to the effect that the so-called basic structure doctrine is not applicable in Kenya. I go on to consider the extent if it is so applicable, but having arrived at that conclusion, I then limit myself to some of the statements and pronouncements that were made by the two superior courts, that is to say, the High Court and Court of Appeal. In this process, I arrived at a conclusion that, contrary to what was decided in error, if you ask me, there is no provision in our Constitution that is unamendable. The question for us to ask is whether the Constitution of 2010 has within it comprehensive provisions, directive principles, and normative prescriptions which are capable of withstanding any efforts from whichever quarter of abrogating it, distorting it, or fundamentally changing its equilibrium. That is the question that we should ask. And when I asked that question, I arrived at an answer in the affirmative. So that leads me to the next issue, whether the president can initiate changes or amendments to the Constitution, and whether a constitutional amendment can only be initiated by Parliament through the parliamentary initiative. In agreement with my colleagues at the High Court and Court of Appeal, I am of a firm opinion, having read the relevant provisions regarding that issue, and in context, I am of the opinion that a president cannot initiate what is referred to as a popular initiative under Article 255 and Article 257 of the Constitution, because those articles talk about an initiative to amend the Constitution by the people. And the word people here is not an ornamental one. It is a serious expression of what forms what we consider a social contract. And both the High Court and Court of Appeal held that such an initiative is reserved for what they call the common mwananchi. But before answering this question, I had to ask myself as to what really constitutes a popular initiative. In my view, a proposal to amend the Constitution through a popular initiative comes into being when there is a felt need for such an amendment by the people. But care must be, however, taken, as advised by Professor Migai Akech in his amicus brief, not to anjikunize, no, but that's my expression, not to anjikunize every stage of constitution making or amendment. In his comprehensive analysis of the history of the constitution making in Kenya, the good professor, rightly in my opinion, decries the tendency to underestimate the role played by what he calls the political elite in the making of the Constitution of 2010. And why do I agree with him? Because, in my view, a democratic polity such as ours comprises of a complex mix of the ordinary, the elite, and the philosopher, each of whom is entitled to meaningfully participate in the popular initiative of constitutional amendment. Therefore, this felt need to amend the Constitution may find expression in various fora, such as our institutions of higher learning, public symposia organized by civil society, religious and community-based organizations, if you remember the Ufungumano caucuses, and even public rallies, as long as those rallies are not organized under the influence of the political class, especially the elected one. These symposia and caucuses and rallies would have as their main objective the need to firstly clarify the rationale and content of the proposal for amendment, and secondly, to sensitize the general public and harness their support for such a proposal. At the end of the day, this felt need will have undergone such repetition, such notoriety, such refinement, and would have acquired such stability and coherence as to be capable of being formulated into a general suggestion or bill as stipulated in Article 2572 of the Constitution. At no stage is very clear to me is the role of the president, qua president, contemplated by the provisions of that article. It cannot have been lost on a casual observer of our painful history that it was the imperial presidency that mutilated the independence constitution through unchecked amendments to such an extent that at the end of the day, this country had lost any pretensions to democracy, rule of law, human rights, or social justice. And by the early 1990s, the Kenyan people were terrified, tormented, and dehumanized lot, deprived of any sense of self-actualization in the manner in which they were governed. It was from such despondency that the people would rise to demand a new social contract, a new order that would not only restore their dignity, but also prevent the executive arm of government, if you like, read the president, and to a certain extent the legislature, from reversing the new equilibrium, from taking them from the paradigm shift to which they had carted themselves. And so to this question, I have no hesitation in holding that the president cannot initiate a popular initiative. That takes me quite quickly as to whether indeed the president did initiate this popular initiative. It's on record, Vida Gazette notice number 514 dated 24th May 2018, that the president appointed a task force named Building Bridges to a United Kenya Task Force, or the BBI task force, if you like. This task force was composed of eminent Kenyans whose mandate it was to address the 9 key challenges facing the country. And these challenges have been identified in a memo of understanding signed between the President and Right Honorable Raila Odinga. Thereafter, the President, Vida Gazette Notice number 264, published on 10th January 2020, appointed a steering committee on the implementation of the Building Bridges to United Kenya Task Force report. One of the terms of reference of that steering committee was to propose administrative, policy, statutory, and constitutional changes that may be necessary for the implementation of the recommendations contained in the task force report. It is out of which this steering committee that we now have the Constitution of Kenya Amendment Bill of 2020. I, on my part, find, although the High Court later described the task force as an unconstitutional outfit, I, on my part, find that there was nothing unconstitutional in the appointment or composition of either the task force or the steering committee by the President. What remains is whether the President can be regarded as having initiated the process that culminated into the bill that we now have. And in conclusion, I have stated that taking everything into consideration, all the stages, all the processes that led to the bill, I find it difficult to distance the President from the involvement and the initiation of the popular initiative. Therefore, I find that the President did actually originate this initiative. The conclusion deriving from this, I shall return to in my final conclusions. And now, next is whether the second schedule to the Constitution Amendment Bill 2020 is unconstitutional. Both the High Court and Court of Appeal found that schedule unconstitutional. I have considered the reasoning by the 2 superior courts. I have looked at the relevant to a similar conclusion that this second schedule to the Constitution of Kenya Amendment Bill 2020 is actually unconstitutional. Fourth, I consider whether civil proceedings can be instituted against the President in person or a person performing the functions of the office of the President during his tenure of office. And I know I have taken into cognizance the submissions by the Attorney General urging the court to find that such proceedings cannot be instituted against the President or a person performing the functions of that office. I also know that there are those who have strenuously opposed the Attorney General's submissions and have argued that such immunity is limited, so limited that the President can on occasion be sued where or if he violates the Constitution, and if he violates any other law when he is not acting in his capacity as the president. And having carefully considered those arguments, I find considerable difficulty in appreciating the rationale or basis upon which first the High Court found that notwithstanding the clear and unambiguous language in Article 1432 of the Constitution, that the President can still be sued in his personal capacity for acts or omissions alleged to be in violation of the Constitution. Why did the High Court introduce the phrase "only protected"? And then turning to the finding by the Court of Appeal, I find similar difficulty, because it is clear that should the President engage in an act or omission that is violative of the Constitution, there are constitutionally recognized pathways through which such violation can be put right. And I have mentioned and discussed them in the body of my judgment. But a more profound legal reason for presidential immunity in both his private and official capacity is to be found in Article 1433 of the Constitution, which provides that where provision is made in law limiting the time within which proceedings under Clause 1 or 2 may be brought against a person, a period of time during which the person holds or performs the functions of the President shall not be taken into account in calculating the period of time prescribed by that law. And what is this law referring to? It must be referring to the law of limitations. And then why would the President be denied the benefit of limitation of actions? Precisely because the President cannot be sued in his private capacity during the tenure of his or her office. And I also state that once a president, always a president until he or she vacates the office, because you cannot be a president today and tomorrow you are not a president, so that you may be so sued. That brings me to issue number 5, the place of public participation under Article 10 vis-a-vis the role of IBC and whether there was public participation. And in response to this, after serious analysis, I find that there was no obligation on the part of the IBC at the time it embarked upon the verification of signatures to satisfy itself as to whether there had been public participation before the bill and signatures were transmitted to it. I do not find anything in the Constitution that obliges the IBC to carry out that function. But what about the promoters of the popular initiatives? What about Dennis Waweru, Mr. Waweru, Honorable Junet, who have defined themselves as promoters? Were they not supposed to undertake meaningful public participation? The argument that I see here against such a proposal is that the process of popular initiative begins with the collection of signatures. And I do not agree with that proposition, because before you collect signatures, there must be something you are offering the people. You are taking to the people either that general suggestion or a draft bill. And if you are seeking their signatures, surely the people must understand the contents of the bill to which they are appending their signatures. I have read the contents of the affidavit sworn by Honorable Waweru, the contents of which state that there was a comprehensive and robust process of consultation. But the contents of that robust consultation are not clearly stated. And so I'm concluding that when it comes to the promoters of the popular initiative, I do not myself think that they undertook sufficient or meaningful public participation under within the meaning of Article 10 of the Constitution of 2010. And now this brings me to the interpretation of Articles 88 and 250 of the Constitution with respect to the composition and quorum of the IEBC. This one has been thrust to us because somewhere along the line, the petitioners did allege that at the time it undertook the verification of signatures, the IEBC lacked the requisite quorum to be able to constitutionally undertake that task. And then I have also looked at the history of the legislative form that prescribes the quorum of IEBC. I've looked at the contents of Article 251 of the Constitution, and I come to this conclusion, that if, as indeed we must conclude, that at the time the IEBC undertook the verification of signatures, it was constitutionally and properly so constituted, how on earth can we then say that it lacked quorum to undertake the tasks for which it was properly constituted? And then my attention has been drawn to the contents of paragraph 5 of Schedule 12, I think, to the IEBC Act, which sets that quorum at 5. And I'm simply saying that as between a constitutional provision, you cannot use the provisions of a statute to override the majesty of a constitutional provision. And having so said, I find that the IEBC had the requisite quorum to conduct the verification of signatures and any other task that the Constitution requires it to undertake. And finally, I come to this vexed question of whether the interpretation of 25710 of the Constitution entails that all, or requires, that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions. I had no difficulty in disposing of this particular issue because it was not ripe, as rightly observed by my colleague Tuyot J.A. of the Supreme Court. And I'm not the kind of person to engage in abstract exercises. Because if we did that, then we would be also encouraging Kenyans, as indeed they have done to us in this basic structure imbroglio, to come with abstract questions and expect us to expend valuable judicial time disentangling the same. So what are my conclusions? One, the basic structure doctrine is not applicable in Kenya in the way and manner in which it has been formulated, because it's no such doctrine, neither does it have a force of law juridically so understood. I've said it is a heuristic device. The four sequential steps of civic education, public participation, and the rest are not also applicable to the process of constitutional amendment envisaged under Articles 255, 256, and 257. Such steps, and not necessarily in that order, would become operative in the event of a seismic constitutional moment, which dictates that the people must exercise their primary constituent power to make a new constitution or re-establish the constitutional order. And three, the president cannot initiate or activate any constitutional changes through a popular initiative process as envisaged under Articles 255 and 257 of the Constitution. For the president actually did initiate the proposed constitutional amendments, and the effect of that, I believe, should be able to come out in the final disposition of this dispute by this court. The second schedule to the Constitution of Kenya Amendment Bill 2020 is unconstitutional. Civil proceedings cannot be brought or instituted in any court of law against the president or a person performing the functions of that office in their personal capacity during their tenure of office in respect of anything done or not done in the exercise of their powers under the Constitution. And 7, the IEBC is not under any obligation to ensure that the promoters of a popular initiative have facilitated public participation before transmitting the resultant bill to it. But I also say that in this particular instance, no meaningful public participation was conducted by the promoters of this bill. 9, the IEBC had the requisite quorum at the time it undertook and completed the verification of signatures. And finally, the interpretation of Article 257(10) in the manner in which the issue has been formulated is not ripe for consideration, not just by this court, by any other court in this country. Before I sign off, my mind races back to those 3 days in this tent during which I and my colleagues here sat patiently, pensively, and attentively, listening to the impassioned pleas from the bar so commandingly assembled. Not that this was the first time I was finding myself having to endure the perorations of counsel. Some of them experienced jurists and others not so senior. But it was such a moment when the basics of a basic structure were basically spewed unto us with such aplomb hitherto unseen, save during the hearing of a presidential election petition. What we were told, however, I also remember that it was on such occasion that we were reminded that our colleagues at the High Court and Court of Appeal, the colleagues at the High Court had built a foundation, and those ones at the Court of Appeal had constructed a wall upon it, and that now it was our turn to paint that wall. But we were not told with which colors we were to undertake this alluring task. I also remember being urged to roar like lions in the wild as we asserted the supremacy of the Constitution. But who could fault counsel for invoking our hallowed symbol of nationhood? Yet at that moment I could not help but cringe, for the sound of a roar of a lion in the wild stirred in me images of the terrifying language so beloved by our politicians, the language of tsunamis, of earthquakes, volcanoes, war, and thunder. And that is why I cringed. And then I remembered that not so long ago, this court had in one of its judgments, and really in true oracular rendition, or so I thought, decreed as follows. But it does appear, as my colleague Judge Lenaola here apprehended, counsel do not read the judgments of this court. And now I am forced to read this decree to you so that even if you don't read it, it shall be acted in your mind. And this is what this court said at that time. What of the argument that this court should not subvert the will of the people? This court is one of those to whom that sovereign power has been delegated under Article 13C of the same Constitution. All its powers, including that of invalidating the presidential election, is not self-given nor forcefully taken, but is donated by the people of Kenya. To dishonestly exercise that delegated power and to close our eyes to constitutional violations would be a dereliction of duty, and we refuse to accept the invitation to do so, however popular that invitation may seem. Therefore, however burdensome Let the majesty of the Constitution reverberate across the lengths and breadths of our motherland. Let it bubble from our rivers and oceans. Let it boomerang from our hills and mountains. Let it serenade our households from the trees. Let it sprout from our institutions of learning. Let it toll from our sanctums of prayer. And to those who bear the responsibility of leadership, let it be a constant irritant. So I say no more. Thank you, Chief Justice.
Thank you very much, Justice Wanjara, for that rendition. I now request the Honorable Mr. Justice Ibrahim Mohammed to deliver his opinion.